Question 1. An investment advisor who only provides advice on U.S. government securities to institutional clients with over $100 million in assets under management would be considered A. An exempt investment advisor under the Uniform Securities Act. B. An exempt investment advisor under federal law, but required to register with the state administrator. C. A federal covered investment advisor, generally exempt from state registration. D. An investment advisor required to register with both federal and state authorities. Answer: C. A federal covered investment advisor, generally exempt from state registration. An investment advisor with $100 million or more in assets under management, AUM, is typically classified as a federal covered investment advisor, meaning they must register with the SEC and are generally exempt from state registration requirements under the Uniform Securities Act. Even though they advise on U.S. government securities, which are themselves exempt securities, their status as a federal covered advisor is primarily determined by their AUM threshold. Remember that federal covered advisors primarily deal with federal oversight, streamlining regulation for larger firms. Question 2. Under the Uniform Securities Act, which of the following statements is true regarding a security sold in an exempt transaction? A. The security itself is exempt from registration, but the transaction is not. B. The security is exempt from registration, and the transaction is also exempt. C. The security must still be registered with the state administrator, even if the transaction is exempt. D. While the transaction is exempt, anti-fraud provisions of the Act do not apply to the security. Answer: B. The security is exempt from registration, and the transaction is also exempt. When a security is sold in an exempt transaction, it means the transaction itself does not require registration with the state administrator. However, this exemption for the transaction does not automatically make the security itself exempt. The security may or may not be exempt. The key takeaway is that an exempt transaction avoids the registration process for that specific sale, but all anti-fraud provisions of the Uniform Securities Act still apply. It's crucial to distinguish between an exempt security, the nature of the security itself, and an exempt transaction, the circumstances of the sale. Question 3. An individual who represents an issuer in the sale of that issuer's own securities to the public must register as an agent under the Uniform Securities Act unless they are selling A. Municipal bonds. B. Securities to existing employees, partners, or directors of the issuer, if no commission is paid. C. Securities to fewer than 10 non-institutional investors within a 12-month period. D. Securities to a single institutional investor with assets over $50 million. Answer: B. Securities to existing employees, partners, or directors of the issuer, if no commission is paid. The Uniform Securities Act provides an exemption from agent registration for individuals representing an issuer in effecting transactions for certain specified exempt securities or exempt transactions. A common exemption is for an individual representing an issuer in transactions with existing employees, partners, or directors, provided no commissions or other remuneration are paid directly or indirectly for soliciting any person. This exemption aims to avoid unnecessary registration for internal, non-commissioned sales. Always remember to check if a commission is involved, as that often triggers registration requirements. Question 4. An agent's registration under the Uniform Securities Act will typically expire on what date each year? A. December 31st. B. October 31st. C. September 30th. D. The anniversary of their initial registration date. Answer: A. December 31st. Agent registrations, along with broker-dealer and investment advisor registrations, generally expire on December 31st of each year and must be renewed annually under the Uniform Securities Act. This standardized expiration date helps simplify the renewal process for both firms and regulatory bodies. Therefore, regardless of when an agent initially registers during the year, their registration will need to be renewed by the end of that calendar year to remain active. Question 5. All of the following are considered unethical business practices for a broker-dealer or agent under the Uniform Securities Act except A. Churning a client's account. B. Exercising discretion in a client's account with prior written authorization. C. Selling away without prior written permission from the broker-dealer. D. Affecting transactions in a customer's margin account without a signed margin agreement. Answer: B. Exercising discretion in a client's account with prior written authorization. Exercising discretion in a client's account is a permissible and often necessary part of managing investments, provided the agent or broker-dealer has obtained proper written authorization from the client. The other options listed, churning, excessive trading, selling away, executing transactions outside the broker-dealer's supervision, and acting without a signed margin agreement, are all clear violations of ethical conduct and regulatory requirements. Always remember that written authorization is a fundamental safeguard for discretionary accounts, protecting both the client and the professional. Question 6. Under the Uniform Securities Act, the administrator may issue a cease-and-desist order against a person found to be engaging in prohibited conduct. What type of hearing must be provided if requested by the person? A. An immediate hearing within 10 days of the order. B. A hearing within 30 days of the order. C. A hearing only after a court has affirmed the administrator's order. D. No hearing is required if the administrator deems it an emergency. Answer: A. An immediate hearing within 10 days of the order. When an administrator issues a cease-and-desist order, the person against whom the order is directed has the right to request a hearing. The Uniform Securities Act mandates that upon such a request, the administrator must provide an opportunity for a hearing, typically specified as immediate, which is commonly interpreted as within 10 days. This provision ensures due process, allowing the individual or firm to present their case and challenge the administrator's findings promptly. Question 7. An individual who provides investment advice solely regarding U.S. government securities and is compensated for this advice must register as an investment advisor unless an exemption is available. Which of the following is not typically considered an exempt security under the Uniform Securities Act for the purpose of advisor registration? A. Securities issued by the U.S. government. B. Securities issued by the state of Illinois. C. Securities issued by the Canadian government. D. Securities issued by a national bank. Answer: C. Securities issued by the Canadian government. While many government and bank-issued securities are exempt from registration, securities issued by foreign governments, other than the U.S. and some Canadian provincial and municipal governments, are generally not considered exempt securities under the Uniform Securities Act in the same way U.S. government or municipal bonds are. Therefore, an individual advising solely on Canadian government securities would typically still need to register as an investment advisor unless another specific exemption applies. Remember that exemptions are narrow and specific, so be cautious about assuming broad coverage. Question 8. Under the Uniform Securities Act, an administrator has the power to deny, suspend, or revoke a registration for all of the following reasons except: A. The applicant has been found guilty of a misdemeanor involving securities fraud within the last 10 years. B. The applicant is insolvent. C. The applicant lacks the necessary qualifications, such as training or experience. D. The applicant refuses to waive a right provided by the Uniform Securities Act. Answer: D. The applicant refuses to waive a right provided by the Uniform Securities Act. The Uniform Securities Act explicitly states that the administrator cannot deny, suspend, or revoke a registration solely because an applicant refuses to waive any right under the Act. This provision protects the applicant's statutory rights and prevents regulators from forcing waivers as a condition of registration. The other options, misdemeanor involving securities fraud, insolvency, or lack of qualifications, are all valid grounds for an administrator to take disciplinary action. Question 9. Which of the following defines an agent under the Uniform Securities Act? A. Any individual who represents a broker-dealer or issuer in effecting or attempting to effect purchases or sales of securities. B. Any individual who provides investment advice for compensation. C. Any person who holds customer funds or securities. D. Any individual involved in the management of a broker-dealer. Answer: A. Any individual who represents a broker-dealer or issuer in effecting or attempting to effect purchases or sales of securities. An agent under the Uniform Securities Act is specifically defined as an individual who represents a broker-dealer or an issuer in effecting or attempting to effect purchases or sales of securities. This definition focuses on the individual's direct involvement in securities transactions. It's important to differentiate this from an investment advisor representative, who gives advice, or a broker-dealer, the firm itself, although some individuals may have multiple roles requiring separate registrations. Question 10. According to the Uniform Securities Act, a broker-dealer must maintain records for a period of A. 3 years, with the most recent 2 years readily accessible. B. 5 years, with the most recent 2 years readily accessible. C. 6 years, with the most recent 3 years readily accessible. D. Permanent records must be kept for customer account statements. Answer: B. 5 years, with the most recent 2 years readily accessible. Under the Uniform Securities Act, broker-dealers are generally required to maintain records for 5 years, with the most recent 2 years kept in an easily accessible location. This rule ensures that regulators can efficiently review historical data for compliance and oversight purposes. This common record-keeping requirement is important to remember as it applies broadly across the industry. Question 11. Which of the following is considered a security under the Uniform Securities Act? A. A fixed annuity. B. A KEO plan. C. An investment contract. D. A whole life insurance policy. Answer: C. An investment contract. The Uniform Securities Act broadly defines security to include various investment vehicles, and an investment contract is a key component of this definition, typically determined by the Howey test. Fixed annuities, KEO plans, and whole life insurance policies are generally not considered securities because they lack the investment risk or expectation of profit from the efforts of others, characteristic of a security. When in doubt about what constitutes a security, think about whether the investment involves an expectation of profit from a common enterprise managed by others. Question 12. If a broker-dealer's agent terminates employment with a firm, who is responsible for notifying the administrator? A. Only the agent. B. Only the broker-dealer. C. Both the agent and the broker-dealer. D. Only the new employing broker-dealer. Answer: C. Both the agent and the broker-dealer. Under the Uniform Securities Act, when an agent terminates employment with a broker-dealer, both the agent and the broker-dealer are required to promptly notify the administrator. This dual notification ensures that the regulatory authority is immediately aware of changes in registration status, maintaining an accurate record of active licensed professionals. This shared responsibility is a critical aspect of regulatory compliance. Question 13. An investment advisor representative, IAR, is defined as any partner, officer, director, or other individual employed by or associated with an investment advisor who does any of the following except: A. Supervises employees who perform any of the listed functions. B. Manages client accounts or portfolios. C. Solicits, offers, or negotiates for the sale of investment advisory services. D. Performs clerical duties for the investment advisor. Answer: D. Performs clerical duties for the investment advisor. The definition of an investment advisor representative, IAR, under the Uniform Securities Act specifically includes individuals who perform advisory functions such as managing accounts, soliciting services, or supervising others who do so. However, individuals whose sole responsibilities are purely clerical or ministerial are generally excluded from the IAR definition. This distinction helps focus registration requirements on those who directly interact with clients or have significant involvement in advisory services. Question 14. Which of the following is an example of an exempt transaction under the Uniform Securities Act? A. An unsolicited non-issuer transaction. B. An offer to sell a newly issued security to the general public. C. A transaction involving a non-exempt security sold to a retail customer through a registered agent. D. A transaction in which an issuer sells its own securities directly to employees, with a commission paid. Answer: A. An unsolicited non-issuer transaction. An unsolicited non-issuer transaction, where a client initiates the trade for a security that is not newly issued by its original issuer, is generally considered an exempt transaction under the Uniform Securities Act. This exemption acknowledges that the administrator's primary concern is with original offerings and solicited transactions, as unsolicited trades initiated by the customer typically pose less regulatory risk. Be careful to note the unsolicited and non-issuer aspects. These are key to the exemption. Question 15. The administrator has the authority to examine the records of a registered broker-dealer. A. Only if there is a customer complaint. B. At any time, as often as necessary. C. Annually, during scheduled examinations only. D. Only with a court order. Answer: B. At any time, as often as necessary. The administrator holds broad powers under the Uniform Securities Act, including the authority to conduct examinations of any registered person's books and records, both inside and outside the state, at any time and as often as deemed necessary. This power allows the administrator to proactively ensure compliance and protect the public interest, rather than waiting for specific triggers like customer complaints. This continuous oversight is a crucial regulatory tool. Question 16. Under the Uniform Securities Act, a client must receive a copy of an investment advisor's brochure, Form ADV Part 2A, at least A. 48 hours before entering into an advisory contract or at the time of contract if the client has a 5-business-day right to terminate. B. 24 hours before entering into an advisory contract. C. Within 10 business days after entering into an advisory contract. D. Only upon written request from the client. Answer: A. 48 hours before entering into an advisory contract or at the time of contract if the client has a 5-business-day right to terminate. The brochure rule under the Uniform Securities Act requires that an investment advisor deliver their Form ADV Part 2A, the brochure, to a client at least 48 hours before entering into an advisory contract, or at the time of entering the contract if the client has a right to terminate the contract without penalty within 5 business days. This rule ensures that potential clients have ample opportunity to review crucial information about the advisor's services, fees, and disciplinary history before committing. Question 17. The Uniform Securities Act's anti-fraud provisions apply to A. Only registered securities. B. Only exempt securities. C. Both registered and exempt securities. D. Only transactions involving agents and broker-dealers. Answer: C. Both registered and exempt securities. A fundamental principle of the Uniform Securities Act is that its anti-fraud provisions apply to all securities transactions, whether the security or the transaction itself is exempt from registration. The intent of these provisions is to prevent fraud, manipulation, and deceit in the securities industry universally, regardless of the specific regulatory status of the security or transaction. This means that even if a security is exempt, selling it fraudulently is still a violation. Question 18. An investment advisor registered under the Uniform Securities Act must renew its registration. A. Annually, by December 31st. B. Biannually, by June 30th. C. Within 30 days of any material change in its Form ADV. D. Only if its assets under management exceed $100 million. Answer: A. Annually, by December 31st. Similar to broker-dealers and agents, investment advisors registered at the state level under the Uniform Securities Act are required to renew their registration annually by December 31st. This standardized renewal period helps streamline the administrative process for state administrators and ensures that all registered entities regularly update their information. Remember that annual renewal is a common theme for state registrations. Question 19. An investment advisor may take custody of client funds or securities under the Uniform Securities Act if they comply with certain requirements, which typically include all of the following except A. Notifying the administrator in writing that they have custody. B. Arranging for an independent public accountant to conduct an annual surprise examination. C. Maintaining client funds and securities in a separate account for each client. D. Holding client funds and securities in a brokerage account maintained by the investment advisor. Answer: D. Holding client funds and securities in a brokerage account maintained by the investment advisor. An investment advisor taking custody of client assets must generally place them in a qualified custodian, such as a bank or broker-dealer, in an account held in the client's name or in the advisor's name as agent for the client, and separate from the advisor's own assets. Holding client funds and securities directly in a brokerage account maintained by the investment advisor would likely constitute commingling or inappropriate custody, failing to meet the strict segregation requirements designed to protect client assets. The core concept here is asset segregation and client protection. Question 20. If an individual represents a federal covered investment advisor in providing investment advice to clients in a state, they must register as an investment advisor representative, IAR, in that state, unless A. They have no place of business in the state and only advise existing clients. B. They solely advise institutional clients. C. They meet the de minimis exemption. D. They are also a registered agent of a broker-dealer. Answer: C. They meet the de minimis exemption. Under the Uniform Securities Act, an investment advisor representative, IAR, of a federal covered investment advisor must register in a state where they have a place of business. However, an IAR can be exempt from state registration if they meet the de minimis exemption, meaning they have no place of business in the state and do not solicit more than 5 retail clients, individuals, in that state within a 12-month period. This exemption provides flexibility for IARs who have minimal contact with clients in a particular state. Question 21. Which of the following best describes the purpose of a consent to service of process? A. It allows the administrator to immediately revoke a registrant's license without a hearing. B. It is a document that appoints the state administrator as the applicant's attorney for the purpose of receiving legal papers. C. It is a waiver of the applicant's right to appeal any decision made by the administrator. D. It grants the administrator the right to conduct unlimited audits of the applicant's financial records. Answer: B. It is a document that appoints the state administrator as the applicant's attorney for the purpose of receiving legal papers. A consent to service of process is a crucial document that an applicant, broker-dealer, agent, investment advisor, or IAR, must file with their initial registration. It designates the state administrator as the applicant's attorney for the purpose of receiving and processing any legal complaints or papers related to non-criminal securities violations from that state. This ensures that even if a registrant leaves the state, they can still be legally served, facilitating the administrator's ability to enforce the Uniform Securities Act. Question 22. Which of the following would not be considered a person under the Uniform Securities Act? A. An individual. B. A corporation. C. A minor. D. A government. Answer: C. A minor. Under the Uniform Securities Act, the term person is broadly defined to include individuals, corporations, partnerships, trusts, unincorporated organizations, and governments. However, a minor, someone under the legal age of majority, is generally not considered a person for the purposes of securities registration and contractual agreements, as they typically lack the legal capacity to enter into binding contracts. This distinction is important for understanding who is subject to the Act's provisions. Question 23. An individual who sells only variable annuities and variable life insurance policies for a registered broker-dealer must register as A. An investment advisor representative. B. An agent. C. A broker-dealer. D. Neither, as these are insurance products. Answer: B. An agent. Variable annuities and variable life insurance policies are considered securities under federal and state securities laws because their value fluctuates based on the performance of an underlying investment portfolio. Therefore, an individual who sells these products on behalf of a registered broker-dealer is engaging in the sale of securities and must register as an agent under the Uniform Securities Act. Don't let the insurance label confuse you. Variable products are securities. Question 24. What is the maximum civil penalty an administrator can impose for violations of the Uniform Securities Act? A. $10,000 per violation. B. $5,000 per violation. C. The Act does not specify a maximum civil penalty, leaving it to court discretion. D. The administrator cannot impose civil penalties, only refer cases for criminal prosecution. Answer: C. The Act does not specify a maximum civil penalty, leaving it to court discretion. The Uniform Securities Act does not explicitly state a maximum dollar amount for civil penalties that an administrator can impose. Instead, it grants courts the discretion to award damages to investors for civil liabilities, and the administrator's powers typically involve denying/suspending/revoking registrations, issuing cease-and-desist orders, and referring cases for criminal prosecution. While administrators can seek monetary penalties in court, the Act itself focuses on enforcement and investor restitution rather than setting a specific cap for administrative fines. Question 25. Under the Uniform Securities Act, if a registered broker-dealer files for bankruptcy, the administrator typically has the authority to A. Immediately revoke the broker-dealer's registration without a hearing. B. Suspend or revoke the broker-dealer's registration, but only after a hearing. C. Suspend or revoke the broker-dealer's registration if it is in the public interest. D. Only issue a cease-and-desist order against the broker-dealer. Answer: C. Suspend or revoke the broker-dealer's registration if it is in the public interest. Insolvency or bankruptcy of a registered person, such as a broker-dealer, is a specific statutory ground under the Uniform Securities Act for the administrator to deny, suspend, or revoke a registration. This action can be taken if the administrator finds it is in the public interest, which is a common phrase used to grant the administrator broad discretion in protecting investors. While a hearing would generally be offered upon request, the fact of insolvency itself provides a clear basis for the administrator to act promptly to safeguard the public.